We have listened to the wisdom in an old Russian maxim. Though my pronunciation may give you difficulty, the maxim is, doverye no proverye, trust but verify.
At the end of the day, a crime is a crime, and you have to be factual. Right. And the only thing I will say is that I've not offered any opinions, theories, or speculation.
Who was the target?
Is Kaylee. The answer is Kaylee. The killer encountered Xana at the bottom of the stairs and attacked her all the way to her room, where she was found murdered on the floor with Ethan. I have the prosecution's forensic analysis done by a woman named Paulette Sutton. But it says this. It says that Xana was attacked at the bottom of the stairs and that she ran across the living room. Some of that blood was determined to be Xana's blood. There's blood found on the beer pong table, including Xana's on the side edge. I want to be specific without saying something that's incorrect.
Ladies and gentlemen, thank you.
Listen to Pavarotti. Can I be your superhero?
Hello, welcome to The Revealing. I'm your host, Pavarotti, and I'm here to discuss the Idaho 4 case. Now, I wanted to discuss Mr. Whitcomb, and I know I put out a video yesterday questioning a lot of things, showing a little bit of the background, going through and taking the information that I heard that he gave on interviews, and I just wanted to point out facts versus fiction. And the reason that I'm really doing that, I don't have anything against Mr. Whitcomb, but whenever I hear him in interviews state over and over that he wants to give information, right, just the evidence and then no opinions, but then turn around and give nothing but opinions based on incorrect evidence, such as Xana's blood being all over the living room. Kaylee was definitely the target based on her injuries. Well, that's where I have to take a step back. And then when he talks about some really key aspects in this case, like that 424 car, the 424 car is a likely perp, in my opinion. And the 429 vehicle that pulls into the driveway is the Ford Explorer. Know that beyond a shadow of a doubt. So when you have somebody that has access to hundreds of thousands of files and photographs and everything else in a case, he said he hadn't had this stuff until after the plea deal. I know how long it takes to go through this stuff. I don't see any possible way that he could go through everything that he's gone through, know all the things that he knows, but still have time to go through Linda Lane videos and mischaracterize certain evidence. So it tells me that he was probably prepped on a lot of those things, and he's just following what law enforcement wants people to believe in some cases. So while the jury is still out on him, because once you get it wrong in the living room with the DNA results from Xana's blood, then you get the whole scenario wrong. You misinterpret the wounds on Kaylee, in my humble opinion, and then you change everything about the case. So it's the specific things that he's going over and giving his opinions on in these interviews that I take issue with, because they're not factual. It's not, here's the evidence, and then let's figure out the truth from the evidence that I'm providing you that you haven't seen. It's, I'm going to give you evidence, not give you my opinion, but then I'm going to steer you in a direction based on my opinion on non-factual things. And that's something I'm always going to call out. But I don't think it's a total loss. I'm going to get his book. I'm going to read every page. Y'all know I will. And he has brought up some things that I find very interesting just in the interviews that I've seen. And I think there's some big implications on those things. And I'm going to cover one in particular in this video right now. And it's kind of a big deal. And I've been working on this one for about 3 days. So I want to talk about the implications of it, kind of what it hurts, kind of what it may open the door for. And then there's a new article out from Fox News about it. So it is getting some headlines. So I'm going to talk about the implications from that, the legal ramifications, and what we're looking at as far as a timeline for anything to happen for Brian Kohberger. So this one's going to be educational and informative. Let's take a look at what we got.
When the knife sheath was taken from the scene, placed in a bag, and I have a photograph of the bag it was originally placed in and sealed up, and I have the documents of where it was transferred. It had no chain of custody form affixed to the bag. So a chain of custody form was affixed, and there are 7 names on it.
Fox News report, Idaho unalivings. Brian Kohberger. New book on Kohberger reveals previously unseen evidence. Claims sheath could be inadmissible. Broken plea reveals Kohberger defense expert raised chain of custody concerns about a K-bar knife sheath. And that's one thing that I want to point out, that it does go into great detail in here about Kohberger's defense expert raised chain of custody concerns about a K-bar knife sheath with the defense team. So it says Turvey brought it up to Ann Taylor and team, which means they could not file in the future newly discovered evidence based on this new claim of chain of custody. And if they tried to do that, it would fall short because we now have public statements of the defense expert telling the defense team about this issue, which, you know, that kind of makes me look a little sideways at stuff, because if that was a strategy, it's now gone, but we'll just put that to the side for now. Exclusive, a new book reveals what Brian Kohberger's trial defense would have looked like had he not changed his plea in the Idaho student unalivings weeks ahead of the trial, and reveals the defense could have argued for the most critical evidence in the case, a K-bar knife sheath to be tossed. And that's not exactly correct when we look at the law. And I've spent 3 days on this law now, and you cannot. This is something that I was perplexed on in mine and Lana's live the other day. But you cannot go to trial and then put people on the stand and then ask for the judge to remove the most critical evidence in the case. You can't ask for the K-bar knife sheath to be tossed at trial. You have to file a motion to suppress before the trial to have the evidence tossed. The most you can do at trial is argue the credibility of the officers based on the evidence. And we're going to get really deep into that in this one. But Christopher Whitcomb's Broken Plea, the explosive search for the truth behind the Idaho unalivings, draws on previously unseen expert reports and other materials that were never presented publicly in court after Kohberger pleaded guilty weeks before his trial. In an exclusive interview with Fox News Digital, Whitcomb revealed that a defense expert raised serious chain of custody concerns surrounding the sheath found in victim Madison Mogan's bed. It is plausible for someone to argue that the chain of custody would have led to significant problems for the prosecution in presenting evidence of any kind of DNA. And if that were to be excluded, then you have a white car and you have the cell tower pings. You don't have a white car anymore. He said, I would say fundamentally, looking at this case, fundamentally, that problem is the biggest problem the prosecution would have. Brent Turvey, a criminologist and forensic scientist hired by the defense, said he became aware of the chain of custody issue after filing his expert report to meet a court deadline. If this had gone to trial, this piece of evidence should have, by any competent jurist, been ruled inadmissible, he said of the sheath. In most cases, in most jurisdictions, it would be. So, in that, you cannot get the evidence declared inadmissible during the trial, though. So I don't understand this statement, if this is actually what he said that they're quoting, because it doesn't line up with the law. And I would think that Brent Turvey would know the law by now. No judge or jury has evaluated that claim. The problem is a chain of custody form is supposed to be something that is created live, Turvey said Wednesday. So if I take a bag of evidence and I retrieve it, I sign that I've retrieved it, put my signature on it, the date, you know, that kind of stuff. The evidence bag appears to have been filled in twice, once on the bag itself and later on a sticker attached to the front. So you can see this is the original bag before these stickers are attached to it. You see the evidence tape here and here, and then they attach these stickers, and the claim that's made is it sure looks like the same handwriting was used to fill all this in, which in turn you could say is a forged sticker. Now, I'm going to show you all of the legal ramifications of that here shortly. The earliest date visible on the bag are the initials BP, likely belonging to lead detective Brett Payne, and the date 11/14/22, written over the evidence tape sealing the bag. Now, that could be a big issue if that's the first thing on there, because we know they collected the knife sheath on the 13th. In the police report, Brett Payne says he took it to the Moscow PD, checked it into the temporary evidence storage on the 13th, and then the morning of the 14th actually checked it into evidence at MPD. So if the first initial on the bag is 11/14, that is a huge issue. And that issue should have had a motion to suppress filed because of it. We'll talk about that more in a minute. Written over the evidence tape sealing the bag, another signature appears to be from Sharon Arredondo, a forensic specialist with the Idaho State Police Crime Lab, signed and dated the bag again on November 16th. The label, affixed sometime later, has 6 recorded exchanges between the 13th and the 16th, written by a single pen in a similar handwriting, according to Turvey. Kohberger's defense team, led by Idaho attorney Ann Taylor, did not pursue his findings before the plea deal. However, Whitcomb said, she did not respond to a Fox News Digital request for comment. So again, they've over and over stated how Ann Taylor was aware of this information. So if she was to file for new evidence, or if the defense team was to file for new evidence discovered in the case, they can't do it because they've already disclosed that she's been informed of this evidence. If the paper trail is flawed, as alleged, that doesn't necessarily mean investigators botched the case, said Paul Morrow, a retired NYPD inspector and Fox News contributor. Yeah, it actually does there, Paul, but what it could point to is that is a vulnerability in the case. So they take a plea, he said. They could have been concerned about losing a juror on that. On the other hand, it's very indicative of what you would do when you have absolutely no defense. You put the procedure on trial instead of the facts. And that's what scares me the most about this whole scenario around this chain of custody, because it is an issue that, as we're going to discuss, could bring up some real ramifications going forward. And what it would lead to is throwing out the evidence in the case of the sheath, which would be fruit of the poisonous tree all the way through. They would have to reinstate a trial, and then they wouldn't have any evidence to actually go to trial, which means it wouldn't be an exoneration. It would be an overturning of Kohberger's conviction based on a technicality. And everybody would still think Kohberger was guilty, yet he would walk free. And that's not an acceptable outcome, in my humble opinion. And that's what scares me about this book and everything else around this situation. But maybe I'm just being paranoid. Morrow, after reviewing images of the evidence bag, said he didn't see a significant problem for the prosecution. You never do, Morrow. That's just one element of Kohberger's defense that never faced jury scrutiny. And Whitcomb said he reviewed thousands of pages of additional documents that he didn't have room to write about. Yet we can't see them, right? Even through public request, we can't see them. A second key element in broken plea is the speculation around wisps of hair photographed at the crime scene in or at least beneath Ethan Chapin's hand. To the best of my knowledge, that hair to this day has never been processed or tested, Whitcomb told Fox News Digital. Remember this is where I get these contradicting statements and it drives me nuts. To the best of my knowledge, that hair to this day has never been processed or tested. Turvey, a senior partner at Forensic Solutions LLC, who has testified in more than 70 trials, found the hair when he traveled to Moscow, Idaho to review evidence in person. I guess Turvey's telling them this, or maybe Whitcomb's telling them what Turvey told him. I'd like clarification on that. They keep saying Turvey said. The FBI lab said Kohberger is excluded, Turvey told Fox News Digital. This is not his hair. Okay, so Turvey says Kohberger's excluded. Best of Whitcomb's knowledge, that hair to this day has never been processed or tested. So which is it? Because you can't exclude Kohberger if it's never been processed or tested. So these contradicting statements drive me a little bit batty. As to who it belongs to, the answer remains unclear. When I saw this information, it changed my perspective on everything, and that's how it started, Whitcomb said, describing his motivation to write the book. Fox News Digital has reached out to the ISP and the MPD for comment. The author is a former member of the FBI's hostage rescue team that was involved in the sniping of people at Ruby Ridge and Waco, an early member of the Bureau's Violent Criminal Apprehension Program. Yep, I mean, one of those early members. He plays in a band, spent years as a journalist and congressional speechwriter, all for the... Never mind about that. Anyway, and has written a half dozen other books. Here's the knife sheath. I don't feel it's my place to challenge what Kohberger told the world, he said in an interview Tuesday. I'm not saying this is a wrongful conviction. He pleaded guilty. He's a well-educated, intelligent, grown man. Jurors never had a chance to weigh in after Kohberger's unexpected guilty plea last year when he admitted to all of the stuff. The plea landed him in prison for the rest of his life with no chance of parole, but he avoided the death penalty. He offered no explanation for the crime, shared no motive, offered no new information. Prosecutors have said Kohberger remained inside for about 15 minutes. No, actually, they said he remained inside for about 13 minutes. Although the initial police affidavit doesn't describe the exact time he went into the house, Whitcomb notes the defense narrative. This is strange. Whitcomb notes the defense narrative that the attacks took place in less than 5. So Whitcomb notes the defense narrative, the attacks took place in less than 5 minutes. Inconsistent with the hours Turvey suspects the crime scene cleanup would have taken. See, now this statement, prosecutors say Kohberger was inside for about 15 minutes. The defense narrative is the attacks took place in less than 5 minutes. But that's inconsistent with the hours Turvey suspects the crime scene cleanup would have taken. So is it the defense narrative that it happened in less than 5 minutes? But Turvey is part of the defense narrative, right? So these I don't know. While there were many outside experts on the case, Whitcomb focuses on 3. Paulette Sutton, in all of her incorrect interpretations, a forensic scientist specializing in blood spatter analysis for the prosecution that can't properly match up the crime scene evidence to the sample number, so she gets the whole scenario wrong, and then Whitcomb follows right along with it. Turvey for the defense, and Christopher Holland, a retired FBI agent and forensic criminologist also working for the defense. Christopher Holland, a retired FBI agent, forensic criminologist also working for the defense. Never heard of Christopher Holland. Sutton, who did not respond to her request for comment, concluded in her peer-reviewed report that there was no physical evidence to exclude a single perpetrator causing the death of those 4 individuals. Yeah. Turvey believes there were at least 2, right? At least 2 perpetrators. Both of their reports have been reviewed by Fox News Digital. They can how did Fox News Digital get their reports? Where did my thing go? They contain graphic crime scene images not suitable for publication. How does Fox News get those reports? Did Whitcomb leak them to Fox News? Whitcomb also obtained access to materials not mentioned in the book, which he told Fox News Digital include images of the evidence bag containing a K-bar sheath with one of the chain of custody forms attached and one without. Whitcomb raised a number of issues that Taylor and the rest of the Kohberger team never got a chance to present to a jury. Kohberger pleaded guilty on July 2nd, 2025, admitting to all 4 unalivings, felony burglary, and a deal that spared him from the potential death penalty. On the night of the unalivings, he searched Google for a local police dispatch audio, according to the public records tied to the case. Well, that was probably because somebody had a wreck and there was cops all over the place out in front of his apartment. He powered off his phone before the unalivings and turned it back on after them. Absence of evidence is not evidence of absence. Idiots. While investigators found none of the victim's DNA in his car after they seized it in Pennsylvania, an FBI analyst determined... Why does it keep doing that? Determined Good grief. FBI analysts determined soil on a shovel found inside it matched dirt from the Moscow area. Well, then, boy, you got him there. You got soil on a shovel that matched dirt in the area that he lived. Oh, my goodness, boy. Absence of evidence is no evidence of absence of any brains. At sentencing, he sat through victim impact statements showing no emotion as the victims' families and surviving roommates excoriated him in their impact statements. Truth be told, I'm unable to come up with anything redeeming. I don't even care what Judge Hippler had to say. Hippler handed down 4 life sentences. As part of the plea, Kohberger forfeited his right to appeal. Remember that? The case's lead detectives, Darren Gilbertson and Payne, afterwards said they still don't know his motive or any other facts in the case whatsoever. I added that part, but we heard the interviews with them. I want you to remember this too, because this is interesting. Why did he take the plea? Turvey asked in a conversation Wednesday, I don't know. I never met him. By design, he does not meet with defendants whose cases he's working on, he said. But he is aware the defense made arguments about Kohberger's mental health and capacity. I want you to remember that. That is very interesting, especially considering Turvey has said it. He was not in a good space to make those kinds of decisions, and that was their argument the whole time, he said. So the idea that you would go in and get him to take a plea when he doesn't know everything, doesn't understand it, well, that's a problem. It sure is. It's a big problem that you're bringing up right there. And that is very interesting to me, which gives me a little bit of hope in this whole thing. Broken Plea is in stores on April 28th. What the heck was this on the bottom here? So let's dive into the legal ramifications that something like this could have. So first, let me just make sure everybody understands exactly what we're dealing with here in this Kohberger case. I've been working on this for a long time, and it's post-conviction relief. As part of Kohberger's negotiated plea deal to avoid the death penalty, he waived his rights to an appeal. When he did that, it started a 1-year clock. Under Idaho Code 194902, because he waived his direct appeal, the strict 1-year statute of limitations to file for post-conviction relief began running 42 days after that July 2025 judgment was entered. The reason it runs 42 days after the judgment is because Garza v. Idaho is in play during those 42 days after the judgment so that you can still file an appeal. And if you don't, and when that 42 days is up, then it starts this clock for post-conviction relief. For some reason, we all thought it was 2 years, but it's not. It's a 1-year clock. So what that means when we look at a precise timeline, the judgment was entered on July 23rd, 2025. The 42-day appeal window under Garza v. Idaho was instituted at that point. So you add those 42 days, then you got the 1-year statute of limitation on the post-conviction relief. And when you do that, you have to add exactly 1 year to September 3rd, 2025, which means Kohberger has to file post-conviction relief by September 3rd, 2026, or the statute of limitations on it expires altogether. So I can assure you I'm going to bust butt between now and September 3rd, 2026 on this case. The second September 3rd, 2026 comes and goes. If Kohberger does not file post-conviction relief, that is my deadline on trying to get justice in this case for this kid. But this is what I want us to understand in all of this. So we've got Turvey here, the defense expert, and his quote, by design, he does not meet with defendants whose cases he's working on, he said, but he is aware the defense made arguments about Kohberger's mental health and capacity. He was not in a good space to make those kinds of decisions, and that was their argument the whole time, he said. So the idea that you would go in and get him to take a plea when he doesn't know everything and doesn't understand it, well, that's a problem. And that is a problem. And we've all asked this entire time, why did Kohberger take the plea deal? We know he had lost a ton of weight at some point between the pretrial motions and the plea deal. He went from a big kid to a tiny kid, and I remember the hearings, and I'm going to show you just an excerpt from them here in a minute, where the defense even brought up his mental capacity. So he is exactly right, and that is probably why he took the plea deal, and hopefully that was only a portion of it, and they were setting up a strategy. But when we go through and we look at this, and we talk about what Whitcomb has brought to the table here with the chain of custody, right? So here's the chain of custody bag before they add these little stickers here with the same handwriting, same pen on all these chain of custody names. Now, here's what we're dealing with this. Because they've now said that they made it aware to the defense team this is not new evidence, and they can't file post-conviction relief for newly found evidence based on this. So, I've talked about this with you many times before. It's the before and after strategies. You got before the plea and after the plea strategies. The right strategy before the plea, if you were planning on going to trial, would have been this route. But when you make a plea deal and you're looking at post-conviction relief, then this route is not the right route, and you have to go back and say this route should have been done. That's how it works. So, what should have happened in this case is the defense should have filed a pretrial motion to suppress the evidence under Idaho Criminal Rule 12. They should have retained a forensic document examiner that examined those signatures and determined, based on his professional opinion, that it was the same person who signed all the names with the same pen. Now, here's what would have happened. It would have been denied, because getting evidence suppressed in a case based on chain of custody in Idaho is almost never granted. And the reason why is they're able to cure it. And what they mean by cure it is they will bring in everybody whose name was on that motion to suppress, on that chain of custody that was signed by somebody other than themselves. And then they would put them on the stand in a pretrial hearing, and they would ask each one of them, did you touch this at this time? And if they said yes, they would cure the chain of custody, and the judge would deny the motion. So when you're looking at it from the strategy of before the plea, Ann Taylor likely would have avoided that situation because she knew that it would be denied in the end. But when you're looking at it in an after the plea situation, when you're thinking of post-conviction relief for ineffective assistance of counsel, then you're not looking at the outcomes of what that suppression hearing likely would have entailed. You're looking at the outcome of not filing that motion. So you can argue that the attorney should have filed a pretrial motion to suppress the evidence. They should have retained a forensic document examiner. And since they didn't, it is ineffective assistance of counsel. And then you've got a really strong argument on ineffective assistance of counsel based on this evidence that we've now got put in our face. Once again, they suppressed the knife sheath. They would have to overturn the conviction and then decide whether to refile charges without the knife sheath, fruit of the poisonous tree. They don't have the DNA. They can just say, we're not going to recharge Kohberger, and the whole world still thinks he's guilty. So it's not an exoneration. It's a let's let him out based on a technicality. The world still thinks he's guilty. They won't, they won't focus on us to reopen the investigation because the killer walked free. That's not what we want in this case. So I go back to this argument right here, though, by Brent Turvey, who says that it was a mental health issue at the time that Kohberger took the plea. And mental health is one of the only rights that you cannot waive when it comes to making a plea deal. It can be argued that Brian Kohberger's mental health at the time of the plea agreement prevented him from understanding his decision. His defense could attempt to have the plea overturned by filing a petition for post-conviction relief based on a lack of mental competency. Now, to successfully overturn a guilty plea on these grounds, a petitioner must prove they lack the present ability to consult with their lawyer with a reasonable degree of rational understanding or lacked a rational and factual understanding of the proceedings. Could they make this argument post-conviction? I would say that they absolutely can, just like Turby said, because they brought it up in pretrial motions. So in the end, the best method of attack with all of this now is a combined attack. Ineffective assistance of counsel, along with all of the other things that we've brought up in this case. The strongest way to argue mental capacity in post-conviction petition is to link it directly to your lawyer's performance. You can argue that your attorney was ineffective in two ways regarding your mental state. You can argue that your lawyer knew or should have known you were suffering from a severe mental crisis or defect, yet failed to request a psychological evaluation or competency hearing before letting you plead guilty, even though I believe they did have a psychological evaluation that may have verified that. And you can combine this with your previous point about the chain of custody. You can argue that counsel was ineffective for not investigating the forged signatures and for advising a mentally impaired client to take a plea deal on a highly winnable case. I guess the key is for the right attorney to file ineffective assistance of counsel and everything else with it, and not get assigned like Meister did Kathy Mabbitt.